Good afternoon, sir. Thank you for the seat, sir.
Rishi Gotha.
Yes, sir.
Correct name?
Sir, I will live in Jaipur only. Vishwakarma Industrial Area, sir.
लो कब किया?
Sir, 2020, sir.
क्या LLM कर रहे हैं?
Yes, sir.
चल रहा है?
Yes, sir. Continuing my LLM. I have just completed the examination of third semester from Department of Law, University of Rajasthan, sir.
किस सब्जेक्ट में करना है?
Sir, tort and crime, sir.
हॉबीज क्या हैं?
Sir, reading is my hobby, sir.
क्या पढ़ते हैं?
Sir, I like to read about crimes, sir, and the recent developments of law.
लॉ में चालू करते हैं।
Yes, sir.
क्या डेवलपमेंट हो रहे हैं लॉ में?
Sir, I was reading about digital rape, virtual sodomy, digital rape, virtual sodomy, and the concept of marital rape, sir.
क्या ख्याल है मैरिटल रेप के बारे में आपका?
Sir, marital rape is actually a rape which is committed by the husband upon her own wife, sir. It has been not recognized in India till date, except an exception provided under the definition of 375 of the Indian Penal Code, where wife is below 18 years of age, sir. The same was pending before the Honorable Delhi High Court. The same has been.
आपका क्या विचार है इस बारे में? इसको इंडिया में मान्यता देनी चाहिए या नहीं देनी चाहिए?
Sir, so far as my limited knowledge to the subject is concerned, there shall be a manyata given to the same, sir.
देनी चाहिए।
Yes, sir.
क्यों? कौन सोचते हैं सर?
Sir, there were many things in our society which has degraded the dignity of a woman. There were sati pratha, there were bal vivah, there were kanya bhoon hatya in our society, sir. But the same was actually targeting the women of our country. I feel this is a thing which actually focuses upon the mentality of the society, which is same as of 100 years before, sir. Just because a rape is being committed by a husband, it must not cease to be a rape, sir.
सती प्रथा क्या थी?
Sati Pratha, sir, when the husband of a woman dies during the lifetime of the wife was forced to be burnt upon the chitta of the husband, sir.
तो सती यदि कोई सती होती थी उस जमाने में तो उसका फैमिली लाइफ पे या सामाजिक जो अपना ढांचा है उस पे क्या विपरीत प्रभाव पड़ता था?
Sir, actually the custom was a problem, sir. There was a small custom into it that she was to be thrown by the father.
वो तो ठीक है, मतलब ये प्रथा था
It was actually showing the dominance of male over the female, sir.
इसका
That
जो प्रभाव
the
है,
life of
जैसे
female.
कोई सती होगी, कोई विवाहिता है, उसके हस्बैंड की डेथ हो गई, वो सती हो गई, तो इस सती होने से मतलब वो भी जल के उसकी भी डेथ हो गई जलने से, है ना, चिता में जलने से, तो उसकी डेथ की वजह से जो बाकी फैमिली मेंबर्स हैं, उसके ससुराल पक्ष है या पीहर पक्ष है या और रिश्तेदार हैं या जो जिस समाज में है वो साथी, उस पर क्या विपरीत प्रभाव पड़ता था?
Sir, it establishes a complete dominance of the male population or the female population, sir. It clearly states that the life of the woman ends with the death of her husband, sir. It was a problem, sir.
जैसे मैरिटल रेप की बात है तो इसके क्या कुप्रभाव हो सकते हैं?
Sir, the same can hamper the institutions of marriage, sir. It will be hard to prove the marital rape which has been committed by the husband, sir, and there is a chance of misuse too, but they are common in other offences also, so that these criteria cannot be sole conclusive proof to deny the fact that marital rape shall not be legal in India, sir.
तो उनको फैमिली लाइफ का तो सोचना पड़ेगा।
सर,
सपोज कि पत्नी एलिगेशन लगाती है मैरिटल रेप के बारे में, तो उनके रिलेशन तो खराब हो जाएंगे।
यस सर।
आगे की जो मैरिड लाइफ है उस पर तो प्रभाव पड़ेगा।
Yes, sir.
उसको कैसे रिकंसिल करेंगे?
Sir, this is a different problem that the women of our country are not able to fulfill their life by their own, sir. They have to be dependent upon the husband. They have to think of the society even before charging a husband for a case, sir.
What is summary trial?
Sir, summary trial has been mentioned under section 260 to 265 of the Code of Criminal Procedure, sir. It is a trial which is to be conducted for petty offences, for offences including theft, for the value of property when not exceeding 2000 rupees, sir, for misappropriation of property, where the value of property does not exceed 2000 rupees, sir, and it can be tried by the Honorable High Court, by the Honorable Magistrates Court, and the maximum punishment awardable is 3 months, sir.
What is session trial?
Session trial has been mentioned under section 225 to 236, I feel, sir, 36, 37 of the Code of Criminal Procedure. It is the trial which is to be observed by the Honorable Court of Session in dealing with the offences, sir.
What is the punishment under section 302 of IPC?
Sir, the punishment is death penalty or imprisonment for life, to which fine shall be added, sir.
And what in section 307?
307 is attempt to murder, sir.
Yeah. Punishment.
Punishment, I feel, is 3 years, or if any hurt has been committed, 7 years. I'm not confirmed with the same, sir. I'll confirm it.
Not correct.
You said that the trial of the Court of Session be commenced from the 225 to 236 or 237. You are not the confirmed.
Yes, sir.
The 237.
Okay, sir. Thank you.
So now you tell me what the section 225 says.
225 says that prosecution shall be conducted by the public prosecutor, sir. The trial itself starts from 228 from the forming of charges, sir.
Then you think that that section 225 is the procedure of trial?
It is not the procedure of trial, but it is the condition requisite for the initiation of trial, sir. That
So
is
the
why
trial of
it
the
was.
Court of Session be commenced from the 226, I think.
Sure, sir. From the framing of charges under 228 or from the disclosure of prosecution's evidence by the public prosecutor, sir.
What do you mean by garnish order?
Garnish order has been mentioned under Order 21, Rule 46A of CPC, sir. Garnish is actually the debtor of the debtor, a debtor who is compelled by the Honorable Court to pay the benefits of a decree which is awarded against a judgment debtor, sir.
What's the main difference between the service of someone in the criminal matter or in civil matter? What's the main difference, if any? If any.
Sir, I feel most of the provisions are exact same, except one exception I can remember. It is Order 5, Rule 15, which states about Rule 15, which states about the service of someone to the adult male family member or the adult family member in CRPC, sir.
Absolutely wrong.
I'll check the same, sir.
CRPC is adult male member
Sorry, sir. I think I reversed the
and
same.
CPC is adult family member.
I'll confirm the same, sir.
And what's the similarity between these?
There is a tendering of copy. Then, if the same is not observed, the service is to be made to.
Similarities between the service of the someone in the criminal matter and
Yes,
civil
sir.
matter.
The general provisions is by the tendering of copies. Second, if the person is not found, the service is to be made to the family member. And in cases that cannot be fulfilled, the service is to be made, which is substituted service, sir. In criminal cases where the service of someone fails, a warrant is being issued in the same cases, sir.
Similarity is that in both the sections or in the order and rule, that explanation received, the servant is not to be included in the
Yes, sir.
family member.
And it was also stated that temporary servant or temporary clerk is not included in the definition, sir.
आप एक रास्ते से जा रहे हैं और वहाँ पे एक डेड बॉडी पड़ी हुई है और उस डेड बॉडी में इसके जो उसने कपड़े पहन रखे हैं उसमें से पर्स निकला हुआ है, आप वो उठा लेते हैं और अपने पॉकेट में डाल लेते हैं और इतने में 2 कदम आगे चलते हैं, फिर एक पर्सन मिलता है और वो आपको थप्पड़ मार देता है और आपकी जेब से वो पर्स लेके भाग जाता है। बताइए किसने ऑफेंस किया, क्या ऑफेंस किया?
सर, जब मैंने डेड बॉडी से पर्स लिया, that is criminal misappropriation of property from a dead deceased person, sir, 404. The rest offense committed was if there was a reasonable apprehension of causing death, it is robbery, or if it is not, the purse is taken from my possession, which will remain as a theft only, sir.
और अगर चोरी का माल अगर आपने रिसीव किया, then I think
Stolen.
411 IPC ना.
Stolen property, sir.
बट प्रूफ ये होता है कि आप इनोसेंट थे, आप गुड परचेजर थे, गुड फेथ में लिया, तब आपके पास क्या रेमेडी है?
Sir, there is a section provided under 454, I think. Innocent purchaser is to be reimbursed the money of property by the honorable court, sir, upon the conviction. Yes,
Who
sir.
gave the money to the such person, innocent person?
Shall be recovered from the convict person, sir.
Difference between void contract and void agreement.
Sir, there is no thing which can be called as void contract, sir, but there is a definition of void agreement under section 2 clause G of the Indian Contract Act, which says that an agreement not enforceable by law is void agreement, sir.
And the
A
void-
contract may become void, but it is not never void of initio, sir. There
Void
is
definition.
there is always a void agreement
What
only,
is the
sir.
primary title of the case Mohari Bibi versus Darmodas?
The
Who is primary?
Sir, the same was continued by wife Mohari Bibi, but I don't remember the original title, sir.
Original title.
I'll soon confirm it, sir. I'll confirm it today only.
Who pronounced the judgment in this case?
Sorry, sir. Cannot recall the same.
Privy Council.
Privy Council.
1 वर्ष या उससे अधिक दंड में कोई अपराध में कन्विक्शन किया जाता है तो मजिस्ट्रेट को कितनी सजा देनी पड़ेगी, वरना कारण लिखनी पड़ेगी, कम से कम कितनी सजा?
Sir, I feel there is provision of 4 or 5 months. I cannot recall the exact same, sir. I'll confirm it.
3 months.
Okay, sir.
हाँ, 3 months से कम देता है तो कारण लिखने पड़ेंगे.
Special
लेकिन
reasons
इसमें
to be
exception
recalled.
है. कौन से?
Sorry, sir. I cannot recall the same.
न्यायालय उठने तक सजा दे या समरी ट्रायल
Rising of the court, sir.
उनमें जरूरी नहीं.
Punishment till the rising of court. And summary trial is to be conducted.
मजिस्ट्रेट अगर किसी मामले में कन्विक्शन कर दिया, दंडित करता है, उसकी अपील भी हो सकती है कहीं? ऐसा कोई प्रोविजन है क्या जिसमें उसकी अपील हो सकती है कन्विक्शन की? जो पनिशमेंट दिया उसकी?
374 of CRPC, sir, to the Honorable Court of Session,
नहीं, मैं कह रहा हूँ हाई कोर्ट में हो सकती है क्या? अपील तो सभी की हो सकती है.
where
हाई कोर्ट में हो सकती है, मजिस्ट्रेट
there is a complaint. In such cases, if the person is acquitted, the same can be made
कन्विक्शन
conviction.
किया है, सजा की है, तो
So I'll have to confirm
7
the
साल
same.
से ज्यादा की सजा अगर की है तो उसकी अपील हाई कोर्ट में हो सकती
Sorry, sir.
है. 7 साल 7 years इम्प्रिजमेंट अगर उसने किया है, 7
Yes,
years
sir.
मोर देन 7 years,
Yes, sir.
तो उसकी अपील हाई कोर्ट में होगी.
I'll learn the same, sir.
क्योंकि मजिस्ट्रेट दे नहीं सकता 7 साल की. क्यों नहीं दे सकता मजिस्ट्रेट 7 साल की?
He has
10 साल मजिस्ट्रेट.
no power, sir. Section 29 confers an imprisonment of either description which may extend up to 3 years. In case of cumulative offences read with Section 31, it cannot be double the punishment which is honorable magistrate is competent to inflict, sir.
ऐसा कौन से ऑफिसर है जिसमें एक्विटल कर दिया नीचे कोर्ट ने, मजिस्ट्रेट ट्रायल में चल रहा है, उसकी अपील हाई कोर्ट में हो सकती है?
Sir, if there is a complaint, the same can be appealed before the Honorable High Court, observing the provisions of Section 378, Clause 4, Clause 5, within a limitation period of 60 days or 6 months, sir.
नहीं, मैं ये नहीं कह रहा. मैं कह रहा हूँ कि ऐसे कौन सी केसेस में करेगा वो, जैसे मजिस्ट्रेट ट्रायल केस है, मजिस्ट्रेट ने एक्विटल कर दिया, अब परिवादी जाएगा या गवर्नमेंट जाएगी एक्विटल के खिलाफ हाई कोर्ट में?
Sir, if the government proceeds Section 377 of CRPC is concerned, and if the sole complainant is seeking the leave to appeal before the Honorable High Court, the same shall be preferred under Section.
नहीं, वैसे तो एक्विटल की अपील भी मैं ये नहीं कह रहा. मैं कह रहा हूँ जो केवल बेलेबल और कॉग्निजेबल ऑफेंसेज है उसमें अगर एक्विटल किया है
The
तो
DM,
उसकी अपील हो.
the district magistrate shall prefer the appeal, observing the provisions of Section 378 CRPC, sir.
चेक बाउंसिंग में 138 के अंदर एक्विटल किया तो उसकी अपील कहाँ होगी?
that has to be appealed in case of acquittal before the Honorable High Court, in case of conviction before the Honorable Court of Session, sir.
District judge or district magistrate, any difference?
District judge is actually a person holding the civil authority.
District
From-
magistrate?
District magistrate is an IS officer holding the authority by his cadre, sir.
District magistrate and collector. What is the difference between?
Sir, I feel there is a difference of working between the both. If he is holding a criminal jurisdiction, the same shall be called as district magistrate. In case of civil, shall be called as collector. If I am not reversing the same, sir, I'll confirm.
सीजीएम की जो कोर्ट होती है क्या वो अपीलेंट कोर्ट होती है?
Sir, there is an exception provided, sir. In case the court of session, the session judge, additional session judge is incapable or busy, the same may be decided by the Honorable Chief Judicial Magistrate. In case the conviction is by the Court of Honorable Judicial Magistrate Class 2, sir. It is an exceptional circumstance, but not a part of general rule, sir.
नहीं सीआरपीसी में प्रोविजन है?
373 or 74 is concerned, sir. 374, a proviso to 374 of CRPC, sir.
ये अग्निवीर योजना जो चल रही है इसके कोई 4 तो आप मेरिट बताइए और 4 डीमेरिट बताइए.
Sir, it is a program to learn and to get earn at the same time, sir. The Agniveer shall be given an opportunity to earn 11 lakh rupees at the date he releases from his job, sir. At the same time, he shall be given a 48 lakh rupees package as a medical insurance. In case an Agniveer dies in performance of his duty, he shall be reimbursed with an amount of 1 crore rupees, sir. In case an Agniveer is injured, the same shall be liable to bring a claim before the tribunal of concerning 15 lakh to 35 lakh rupees, sir. Demerits, it reduces the permanent job to a contractual job of 4 years, sir. And another demerit can be, I'll have to think about it, sir. I don't.
इतनी सारी कोई ना कोई ये इतने सारे लोग वो कर रहे हैं.
Sir, they are protesting on the basis that a permanent job is now reduced to a 4-year job only, sir. And also there was a problem that the last recruitment of 2019 is being cancelled just to fulfill the candidature of the Agnipath scheme, sir.
2-3 साल से तैयार हो रही थी.
उनको रिजेक्ट कर दिया गया है, सर.
उनको उम्मीद थी कि
क्या हम ये प्राइवेटाइजेशन की तरफ बढ़ रहे हैं इस तरह के सिस्टम से? क्या आगे जुडिशरी का भी प्राइवेटाइजेशन हो सकता है? ठेके पे दी जा सकती है जुडिशरी को?
सर, जुडिशरी का प्राइवेटाइजेशन अगर होता है तो वो दर्दनाक होगा, सर.
नहीं हो नहीं रहा. क्या अभी चल नहीं रहा प्राइवेटाइजेशन का? कोई एग्जांपल देंगे जुडिशरी का है? आर्बिट्रेशन क्या है?
Arbitration, it is actually the example of Indianization of judiciary, sir.
We are paying to arbitrator so that कि वो क्या फैसला करना है दोनों पार्टी देती हैं.
Sir, actually in my opinion,
Privatization ही है.
in my opinion, the same is an exceptional circumstance to overcome the pendency before the court, sir. As far as the privatization of judiciary is concerned, I'll have to read it about, sir.
what is the difference between arbitration and mediation?
Sir, there is an arbitrator appointed to resolve the dispute as per the Arbitration and Cancellation Act, whereas in case of mediation, a mediator is to be enrolled between the two parties to mediate and to arise upon a good settlement, sir.
And what is remedy against the award of arbitrator?
Sorry, sir, no information. I'll confirm.
Arbitration आपके है सिलेबस में?
No, sir.
आपने अभी कहा ना कि प्राइवेटाइजेशन आर्बिट्रेशन का आपने बताया, तो आपने कहा इंडियनाइजेशन.
Yes, sir. It is the Indianization of judiciary, sir.
How it is Indianization of judiciary?
Sir, there was a concept of resolving disputes by mutual discussions, and it is actually the same procedure which is observed before the honorable members of the forum, sir. Arbitration, cancellation, mediation, lok adalats, judicial settlements.
According to you, there is a difference between arbitration and mediation. So, in mediation, the dispute is resolved by mutual consent and a settlement is reached, the mediator does not decide the matter, है ना?
Yes, sir.
और जबकि आर्बिट्रेटर डिसाइड करता है, उसका जो अवार्ड है इट इज़ लाइक ए डिक्री ऑफ द कोर्ट. तो फिर डिक्री ऑफ द कोर्ट है, तो हाउ इट इज इंडियनाइजेशन ऑफ जुडिशरी?
Sir, there has to be an arbitral agreement already agreed between the parties, sir. It is just
उसमें आर्बिट्रेशन में सेटलमेंट का चांस कम होता है. उसमें मेरिट पे सारी कार्रवाई होके लाइक ए कोर्ट एविडेंस भी होती है, सुनवाई भी होती है, बहस भी होती है, फिर जजमेंट होता है, अवार्ड जिसको बोलते हैं, इसके खिलाफ आगे रेमेडी भी है. तो जो हमारा जो इंडियनाइजेशन का आपका शायद जो पंचायती वाला जो था, पंचायत के माध्यम से सुलझाने का, वो कहना चाह रहे थे आप. तो ये एलिमेंट मीडिएशन में तो है, लेकिन आर्बिट्रेशन में किस तरह से है ये?
Sir, it is a small way which we have resolved to overcome the pendency before the honorable court, sir. And I feel it was Indianization of judiciary just because both the parties were given an opportunity to explain the terms of conditions which they have already agreed, sir. That is why I said it Indianization of judiciary. As far as your opinion is considered, sir, I'll consider the same too and I will read about it, sir.
तो आर्बिट्रेशन तो सारी दुनिया में चल रहे हैं.
Yes, sir.
तो इसका मतलब आर्बिट्रेशन जहाँ हो रहा है, तो इसका मतलब है कि लोग आगे इंडिया का जो पुराना सिस्टम था बातचीत के माध्यम से अपने विवाद निपटाने का, वो एडॉप्ट कर रहे हैं.
I feel most of the laws, for example, the concept of Purva Nyaya was taken as res judicata. There can be an Indianization program seen in the laws of various countries, sir. For example, the concept of Purva Nyaya, which we observed, is observed as res judicata before the rest of the foreign courts, sir.
res judicata criminal में कहाँ है?
Criminal res judicata is section 300, depending upon the maxim or Trophes Actis,
Constitution.
Article 20, Clause 2 of Indian Constitution, sir.
What's the difference between 913 or 97 CPC?
Sorry, sir.
Difference between 913 and 97, if any, under the CPC.
Sir, if a decree has been passed, it is subject to 913 application, but where plaintiff omits to appear before the honorable court, it becomes a matter of Order 9, Rule 7, sir.
913 की applicability, what's the applicability of the 913?
Where there is an ex parte decree has been
Ex parte
passed,
degree.
the same shall be resolved by the application of 913, sir.
Suppose the disputed party becomes your landlord, then what you will do at that time?
For
At
instances,
the time of the litigation, the disputed parties is your landlords. You are the tenant on the disputed party. Then, what step you will be taken at that time?
for what, sir? I'm unable
Disputed
to.
parties, if the disputed parties belongs yours landlords, तुम्हारे मकान मालिक हैं disputed
When
party.
you selected in your court such matter being in your court, he is asking in this.
डिस्प्यूटेड पार्टी अगर आपके मकान मालिक होते हैं और आप उनके बहुत पुराने 10 साल पहले किराए पे रहते थे, तो आप क्या करेंगे? कौन सा स्टेप उठाएंगे आप?
Sir, in no case the relation between parties shall affect the infringement of my rights, sir. It will remain the infringement of my right, even if he is a landlord or my neighbor or the DM of the district, sir.
Any provision in any law
For what, sir?
for this? If the disputed party is relative of you, any provision in the CRPC or CPC?
Sir, I remember where the magistrate cannot decide a matter to which he is related. I'm not concerned about any other law, sir. I'll read the same.
CRPC.
There is a provision under CRPC where magistrate cannot decide a matter
Interest.
in which he is interested, sir.
Section.
Section 479 of CRPC, sir.
Right.
Good.
ठीक है